Aloha, this is Professor Porter. This is Introduction to Mock Trial, the course, a 10-part series. This is part 9, focusing on witness, how to be a solid witness in mock trial. As always, this is a YouTube channel, so please subscribe, follow the other videos, see the other videos that will be helpful to your path in mock trial, and also follow these hashtags and also on Twitter, and you can reach out in Gmail. Any questions or requests for videos. Now, first, you have to recall that the role of witnesses are critically important in trials, but they're also critically important in mock trials because it's the meat of the trial. There are bookends of jury addresses where attorneys are speaking straight to the evaluators who are serving as jurors and often sitting in the jury box. But in between, everything in between the opening statements and the closing arguments are witness examinations. And typically there's 2, 3, 4, maybe more witnesses per each side. So maybe the plaintiff in a civil case, prosecution in a criminal case, they'll go first. They'll have their set of witnesses that they'll go up one at a time, usually in a batting order of their choosing, to say, here's the direct examination of our first witness, followed by the defense has the opportunity to cross-examine that first witness. And maybe, if allowed by the competition, the people on the plaintiff side, prosecution side, can have limited redirect of that first witness. Then the second witness, direct examination, followed by the other side giving cross-examination. Maybe, if allowed by the competition, a brief redirect. And it goes on that way until the prosecution or plaintiff in a civil case rests. Then we go to the defense case, almost the same exact thing flipped around. The defense calls its first witness, and they proceed on direct examination, followed by plaintiff or prosecution in a criminal case, cross-examination of that witness, and if allowed by the competition, redirect, proceed to the second defense witness. So witnesses and witness examinations are the entire middle and the most important part. It is the evidence. It is the ammo and the mechanism by which you get in exhibits and the testimony that you'll use to craft your closing statement and aim towards that closing statement that you hope to give, consistent with your case theory and consistent with the theme that you and your team have developed. Now, in mock trial, we get witnesses from one or two places. One I'll mention, but it's not the subject of this video because we can do little about it. But two is the one that we'll talk about the most. Now, first, sometimes competitions provide the witnesses. They'll have volunteers, they'll maybe have students, they might have younger students from the area, they might have people that are just volunteering their time. And as attorneys and members of a mock trial team, it's not like real life. You don't get to spend any time with these people. In real life, you would spend time with your witnesses. You would be not only asking them questions to develop what are the facts at trial, but you would also, once the facts at trial are kind of set and you've investigated the case, you're going to spend a lot of time with them to prep them for their direct examination and give them what to look out for cross-examination. And we'll talk about that in a few slides. But in this one form of mock trial competition where they provide the witnesses for you, you really don't have any opportunity to spend any time with them ahead of time. You get your team's theory, you get your team's theme straight, you understand what questions you want to ask on direct and even the direction you want to go in blocks for cross-examination, but you're going to meet someone for minutes before trial. In law school, when they have competitions that proceed this way, you often get a 5-minute or a few minutes to meet with the prospective witnesses. And it's a horrible term, but they call it woodshedding because they're essentially in this speed drill to tell them what are your expectations for them. You hope that they know the facts, what to look out for on cross. Some of the things we'll talk about this, but you do it in 5 minutes and it's a false universe. This video really addresses the second version of mock trial when the witnesses come from your team. And sometimes in high school and college mock trial, it'll actually be a role that's your only role at trial. You're maybe a newer member of the team or a less experienced member of the team, and your role at trial is to assume to play this one witness as opposed to the role of one of the attorneys, whether it's a plaintiff's attorney, a defense attorney, a prosecution in a criminal case, or defense attorneys in a criminal case. Instead of being an attorney role, you're a witness role. And this video is about how to be a solid witness and how to advance your team's goals as a witness. And I think the number one thing that I'll start with, that if you remember one thing from this video, here's what I want you to remember. When you're the witness, you are not playing the role of attorney. I think the number one mistake that happens with students or people in mock trial, particularly law students when they play mock trial, they want to keep their law brain, legal brain going as they assume the role of a witness. And the witness could be a car mechanic, could be a plumber, could be a person on the side of a street that saw a car accident, could be a doctor, but they're not typically a lawyer. And you shouldn't be advocating or trying to aim your answers or try to win from the witness stand. So that's the one part I want to stress here. I'm going to give you some hints as to how to be a solid witness and how to contribute to your team in the role of witness, but do not combine it with being an attorney. Do not try to win or assist your team in a legal way from the witness stand. That's the most critical error. And as a seasoned evaluator, when I'm sitting at mock trial, I can tell when a student's trying to do that. I can tell when a student's guiding their answers because they're trying to sort of navigate and win. And probably the greatest example of that is just making stuff up as you go along. There's a fact pattern, there's a role, there's what happened in the case, and you are allowed to stick to those facts for your testimony and really any reasonable inference from those facts. So, the idea that if the fact patterns don't provide that you where you went to college or where you went to medical school, but you're assuming the role of a doctor, well, if someone asks you, did you go to medical school? That's a reasonable inference because, of course, you're a doctor. You had to go to medical school. That's reasonable, even though it doesn't say it in the facts or say where you went in the facts. So that would be something that you're not really making it up. It's a reasonable inference. But if you're just a person on the side of the street who saw a car accident and there's no details about your background, it's not a reasonable inference that you were awarded a Purple Heart at war because you served in combat, and none of that's in the fact pattern. That's just making stuff up. So as an attorney and as a team strategy for the witnesses, do not make stuff up that is not reasonable from the facts, right? And do not put your legal brain on, put your attorney brain on in the witness stand. Don't try to win from the witness stand. So we're going to talk about 5 different things that you can do to be a solid witness when you're on the mock trial team, but you're playing the role as a witness. And sometimes even in law school competitions, you're an advocate on one day if the plaintiff's or prosecution side in a criminal case goes, and then on a next time where you're going through the mock trial or next day when the defense team is going, you switch roles. That is now you're the attorney and your colleagues are the witnesses. So there's lots of times when we might end up being a witness. But the first one is to just know the character. You have to assume the role of the character. This is like acting 101. I put the picture of the physician up here tending to a patient because if you're asked, I think this is the easiest way to think about it. If you're going to be a doctor, if you're going to be a medical professional as your witness role, and the testimony is naturally going to assume that it's dialed up. I mean, you're going to be talking about diagnoses, you're going to be talking about conditions, there's probably going to be some Latin words and some 10-cent words thrown in there. You got to get your arms around it, and you got to own that character and assume that character to speak to it as if you're a doctor. From the moment they say, the prosecution or the plaintiff or the defense next calls Dr. Smith to the stand, and you are the role of Dr. Smith, you're in that character. You go to the stand, you take the oath as a doctor, and you're going to answer questions about your background, and you're going to answer questions about what you did in this case or what you reviewed in this case, and you're going to talk about your opinion as a doctor. So you're not a second-year law student. You're not a sophomore in college. You're not a junior in high school. You are a medical professional. And what you want as a comment after, what you want as feedback after a mock trial competition is, wow, you were so good at your character and you knew how the character would answer the questions in the context of this that I actually thought you were a doctor, even though you're a 16-year-old kid or you're a second-year law student. That's what you want. You have to assume that role and you have to know that character up and down. So it is on you. Let me be very clear. It is on you. If you're playing an auto mechanic, if you're playing a plumber, if you're playing a woman on the side of the street when 2 cars crack into each other, so you're what's called a percipient witness. You're just a fact witness. You're just describing what's within your personal knowledge that you saw on a given day. You got to know everything in their testimony. So if they describe something in a certain way, or they use a certain word, or there's specifics to the technical knowledge that they advance as someone like a doctor or another type of expert witness, well, go research it. Go figure out what it is so you know what you're talking about, right? Um, uh, I can remember doing a mock trial even as long ago as doing a mock trial was for me, and it was all about necrotizing fasciitis, and essentially this injury that happened underneath a patient's cast, and we had witnesses that were medical in nature and talking about the specifics of this condition. Well, you have to know what that is, and you have to know it to the level that a doctor would talk about it. So I can't underestimate that. You cannot wing a role. You cannot just kind of speak extemporaneously and hope it comes out like a doctor. This is a practice thing. Every drop that's in that deposition testimony, or that's in that resume or curriculum vitae, everything about that role that's given to you in the fact pattern, you got to internalize, and you got to know. You got to be that character when you're called to the stand. And these first three are going to sound similar, but in addition to assuming the character, you really have to know the facts of this case. And I'm going to qualify that with, you got to know the facts of this case through the prism and through the perspective of the witness role that you've been assigned. So if you're a doctor and you saw this patient that's important to this fact pattern, from the moment they walk in, everything in their chart, everything that they considered, everything about your interaction with that patient, just imagine that place in the timeline. All those facts are yours and available to you and within your realm of what you have to understand. Now it's going to be different, and it's going to be more. So picture the concentric circles. Here are all the facts in the case. You're responsible for the facts in the case that impact your role. You don't have to know what somebody else said or did on a certain day. You have to know the role of the medical professional and the doctor in that visit. And even smaller than that is going to be, what are the facts that your attorney, your team, is presenting at trial. So you have to know all the facts that bear on your character, and some subset of that, some concentric circle of that, will be the facts that we're going to present at trial. So you know all of them that bear on your character, and then you're going to work with your attorney to which ones you're presenting at trial. But you are responsible for these facts. If there's 6 different days that, as a doctor, this was your patient, and you're going to testify about your interaction with that patient, and on 6 different days there were 5 sets of vitals with blood pressure and with temperature and with different things, and the medical records include those 5 separate days and 6 separate days and 5 different facts, well, you're responsible to understand those 30 data points and how they change on that day, right? And it fuels your testimony. And sure, all these mock trial fact patterns have kind of testimony that you've given before. They might have statements to the police. They might have deposition transcripts. They have something else. They have reports that you filed and statements that you said. Yeah, that's what you've said before, but the facts are going to be a wider swath of information than just what you've said before. And just because you said it before doesn't mean your trial team has to present it at this trial. You're making your own choices based on your case theory and your case theme of what's important and what's aligned with your case. So there's all the facts in the case. You don't have to know all of them. You have to know all the facts that bear on your role as a witness. What did you see? What did you perceive? What are you supposed to know and have reviewed as an expert? And then understand what's the subset of that you're going to present at trial. Know your character, stay in your character, be a doctor the whole time on the stand, but also know all the facts that you're responsible for. If there's a word that you don't know that's in your prior statement, find out what it means. If there's data on that medical sheet that is part of something that you reviewed, find out what every piece of data means. So that's the way you have to think about knowing the facts of the case, because as we'll discuss, even if it's not part of your presentation with your presenting attorney in direct examination, you have to know all the facts, because it could be ripe for a question and cross-examination from your opponent. So it might not be part of the thing you prep with your other teammate and the thing you go over. Maybe you're just talking about the interaction on days 1 through 3 and with this patient. Well, they might ask about days 4, 5, and 6, even if it wasn't part of your presentation, and they may, under the rules of evidence, be allowed to ask about it. You got to know those facts too and be able to speak to those facts too. And here's a slightly different thing. So know your character. You're going to be that medical professional. You're going to be that plumber. You're going to be that person on the sidewalk that saw the two car accidents, right? That's the role you're assuming. Then you're going to know the facts, everything that you would have encountered if you were that person. What are the facts you would have been confronted with? What are you expected to know for this trial? And then here's that third concentric circle. Here's that subset. You on direct examination with your teammate. So I'm Dr. Smith. I'm a member of the mock trial team. One of the attorneys on my team could be plaintiff in a civil case, prosecution in a criminal case, defense attorney, and they're going to call Dr. Smith. I am your witness. So one of my colleagues who's playing the attorney is going to work extensively with me playing Dr. Smith as the witness, and we're going to make decisions. And oftentimes it's a team decision working with the coaches, but also this attorney, this person playing the attorney, their decision as to what have they brought forward, what is part of the direct testimony. Well, I have to know that. This is really as close to it gets as what is the stuff that is important to us given our case theory, why we think we're going to win this case, given our theme, how we've described our case with that movie preview or that book cover, given the way that we want to present this case, what do you need from me, Dr. Smith? What of the universe of stuff that I could talk about, all those medical records, my whole deposition transcript, what is the stuff that you want to pull forward into this trial? I need to know those parameters, and I need to know what's the part that you want in and what's the part you want out, okay? I'm the witness, and just think about this. There's an ethical responsibility that attorneys have in the case. It's the witness's testimony. A lawyer never tells a witness, no, don't answer it that way, answer it this way. That would violate ethical rules, and it's for a different time and a different course. But just know, the attorney's not telling someone how to answer. It's their testimony. What you can do is say, of all the things, maybe you have different parts of your answer that you could offer. You have 1, 2, 3, 4, 5, 6 points to answer this question. We can talk about as a presentation style, as a strategic effort. Well, I'm going to ask this first question, and really all I want is just for you to talk about 1 and 2. Then I'll ask a next question where I want you to talk about in 3 and 4. And then finally, there'll be a third question you could talk about 5. We're breaking up how we answer it, but it's the witness's testimony. So that part is what witness prep is all about. When you're preparing your witness, we're going through, as we'll talk about, almost akin to a script. Here's the question. Here's our expectation of how your testimony is going to come out at trial. Here's the way you're going to respond. And we'll work on both. And we'll work on making my question better and maybe work on the presentation of your response as witness better. But you have to know where you're going to go. This should come off like an extremely prepared, no surprises, back and forth with a colleague. But also, as we're going to discuss, it's got to be extemporaneous. It's got to sound like someone's asking you a question for the first time. You're interested in the question, and then you're giving an answer that most of the people in the room don't know is coming. Only the person who's playing the attorney knows it's coming.